Hi, in this video I'm going to talk to you about defences, and sort of defences properly so called, those ones that we deal with in chapter 14 of the textbook. Now there's a few little bits of advice I want to give you here, mostly about sort of the way in which you should think about defences and the way in which you should analyse them when it comes to problem questions in particular. So the first thing to mention is that whenever you're asked to discuss potential liability, it's always relevant to consider defences. So logically, in order to decide whether someone has committed a crime or not, you also need to look at, even though they've committed perhaps the elements of that offence, actus reus and mens rea, if they have a full defence, a complete defence that exculpates them, then the outcome is that they will be acquitted. If there's a partial defence, of course, to murder, then the outcome would be manslaughter, etc., etc. So with every question that you answer, it's important to look at the potential for defences applying. Now, having said that, it is always important to consider the potential for defences, but it isn't appropriate with problem questions to analyse every single defence to rule it out one by one. Simply and practically that wouldn't be appropriate, either because it would be a waste of words to a large extent in, say, a coursework type question, or in the context of an exam. You would spend a lot of time doing it and you'd be missing the point. So when it gets to the stage of you've looked at the potential crime, you've identified the potential offence, you've looked at the actus reus and mens rea, and you found there is liability for that offence, the next stage is then to think, could there be potentially a defence that applies? And that's a mental question, where you should think through the various types of defences and think whether there's one that's potentially applicable. If the answer is no, then you don't need to discuss defences, or if you do discuss it, it would simply be to have one or two sentences saying it doesn't look like there are any defences that would be applicable in this scenario, and therefore it's not necessary to go into detail. Now when you're doing that, have a think about the types of motivations that can lead to potential defences. And in order to help you with this, we put a flowchart in chapter 14 detailing the various defences and the sorts of cues that you should look for within problem facts that might lead you to consider one of those defences in more detail. So for example, if you see that the defendant was threatened in some way to commit the offence, then you should consider duress by threats. Even if one of the elements is lacking, you should still discuss it, because a threat should lead you to discuss it, and then you can discuss whether the elements are satisfied or not. If there isn't an explicit threat from a person, but there's some kind of circumstantial threat, so I don't know, for example, there's a tidal wave coming and so it leads the defendant to break into a car and drive away, then that essentially the threat imposed by that tidal wave on its way should lead you to discuss duress by circumstances, for example. If there's force being used by the defendant committing an offence in order to protect himself or herself from external force, then you might want to discuss self-defence, for example. So in all of these ways, you look for these cues within the facts, or in relation to necessity, a kind of balance of evils. But you look for those cues within the facts. If there is some indication that a defence might be applicable, then you should discuss it in detail. But if there's no indication, then there's no requirement for you to go through like a tick box through all the various defences that are potentially applicable, because it's simply a waste of your time within the question answer. Incidentally, just when I mentioned necessity at the end there, just as we use it within the flowchart, it's often useful to think of necessity as a backup option. Generally, you would always analyse the other defences first. Insanity, duress by threats, duress by circumstances, and self-defence, the public and private defence. These are the defences that you would look to first. And if none of those are applicable, but you still think on the balance of evils what the defendant did was in some way justifiable, it's then that you look, reluctantly I might add, to necessity. And that's the same approach that courts take. And the reason why necessity essentially forms almost an imperfect kind of safety net below the other defences. It's there to provide a defence where the other defences fail to, in extreme circumstances. But the difference with necessity is there are basically very few, almost no legal rules at all, which actually apply to tell you when necessity applies in practice. And so the courts have been consistently reluctant to apply it to scenarios. So in that sense, you should take your lead from that, and when you're answering a problem question, for you as well, that should be a reluctant safety net, as opposed to a defence you analyse alongside the others. And then when you're analysing the defence, just make sure you remember that the language of actus reus and mens rea is no longer appropriate. That's the language we use to describe offences. When it comes to a defence, you're simply discussing the elements of that defence. If they are all satisfied, then it leads you to an outcome either in relation to an acquittal or, as I say, in relation to insanity, the special verdict of not guilty by reason of insanity. Thank you.